again, congratulations to teams 46, the petitioners, Christopher Campbell and Lauren Nenig, and team 8, the respondents, Arthur Seskin and Benjamin Sampson. We have 6 distinguished justices on our panel today. Ronald L. Ellis, who is a United States Magistrate Judge for the Southern District of New York. Honorable Ronald Meisberg, who's joining us once again. He is a partner with Proskauer Rose and formerly a general counsel to the National Labor Relations Board. Honorable Joseph E. Arenas, who is a District Court of New Jersey judge. Honorable Wilma B. Liebman, the immediate past chair of the National Labor Relations Board. Honorable Mark Firestone, also a professor here, who is Corporate and Legal Affairs and General Counsel for Credit Unions, as well as Interim Dean Carol Buckler. Everyone turn off your cell phones if you need to go to the bathroom, go now. And I'd also like to introduce the authors of our fact pattern, Shannon Hagan and Amanda Ross.
Hi everybody, thank you for coming. Thank you for reading the fact pattern, for making the fact pattern really come alive. It was hard work writing it, and I'm sure it's been just as tough to argue it. And I hope you all enjoy everything. And here's Ian Thomas.
And before you guys go, thank you for the congratulatory flowers.
I just want to briefly thank all the members of the Moot Court Association again, who really have helped this competition be a success. With 46 different teams here, it's obviously a lot of work to manage everything that's going on, and it would not have been possible without the help of every single member of the Moot Court Association. And I also wanted to particularly thank Larry and Alexa, who have done an absolutely incredible job. I honestly have watched them every step of the way from, over the summer till now, and they handle everything with such professionalism, and they really think of everything and lots of foresight. They've just been doing an incredible job, and I'd really like to ask everyone to just give them one more round of applause.
Don't do it again when Alexa comes in. Okay.
So I think without further ado, we're going to get this show on the road.
And I think it goes without saying, please, don't talk in the background. This is being streamed around the world. It is being streamed online, though, for people to watch from home or wherever. But we're going to get started, and best of luck.
Business before this, the Honorable Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. The Supreme Court of the United States is now in session. Justices Ellis, Firestone, Arenas, Liebman, Meisberg, and Chief Justice Buckler presiding.
Be seated.
The first case on this calendar, this 25th day of the month of March 2012, is Fly Above Warehouses Incorporated, petitioners cross respondent against Mary Lou Costanza et al., respondent cross petitioner.
Counsel?
Bailiff. Good afternoon, Madam Chief Justice, Your Honors, and may it please the Court. My name is Christopher Campbell, counsel for Fly Above Warehouses Incorporated, with respect to Fly Above's motion to dismiss on the basis that obesity is not an impairment under the ADA unless it is accompanied by an underlying physiological condition. My co-counsel, Ms. Lauren Netting, represents Fly Above with respect to the class arbitration waiver in this case. Your Honors, with the permission of the Court at this time, I would like to request 1 minute for rebuttal. Thank you. Your Honors, in this case, the employees have failed to sufficiently state a claim that survives a motion to dismiss for two reasons. First, with respect to the actual prong of the Americans with Disabilities Act, the plaintiffs have not alleged an ADA impairment because they have not alleged that obesity is accompanied by an underlying condition in this case. With respect to the employee's claim for a regarded as discrimination case, the plaintiffs in this case have merely alleged that the employer perceived them as lazy. That perception does not extend to their weight. Your Honors, with respect to the 2008 amendments under the ADA,
Counsel, isn't obesity a disability if it substantially impairs a major life activity?
respectfully, Chief Justice, no. The requirement for the actual prong under the ADA requires a physical or mental impairment that substantially limits a major life activity. That physical impairment needs to have an underlying disorder or condition. The EEOC...
Where is that in the statute?
Your Honor, it is not directly stated in the statute.
Then where does it come from?
It comes from a case called EEOC versus Watkins Motor Lines Incorporated in the Sixth Circuit in 2006. That court and a previous court case in the Sixth Circuit, Andrews versus Ohio, both stated that an underlying physiological condition is required. They did so based on the fact that the EEOC interpretive guidance provided in the Code of Federal Regulations provided for the fact that physical characteristics, such as weight, such as height, eye color, or hair color, require an underlying condition.
That's no longer the EEOC position, is it?
That's correct, Justice Arenas. In fact, the EEOC's current position is that morbid obesity is a per se impairment. However, the major issue with that particular rule is that a per se impairment based on morbid obesity, in other words, a weight that is 100% over the norm as defined by the EEOC, is an arbitrary standard. In fact, for example, a football player, an NFL football player, could possibly satisfy the BMI requirement where that particular player has a height and weight that, based on the BMI calculations, could produce a result that the BMI is over 30. And as prescribed by the CDC, the Centers for Disease Control and Prevention, that would qualify an employee as being obese. The World Health Organization...
If I have an obese person, forget morbid or not morbid, just obese, who has difficulty walking, difficulty bending, difficulty breathing, all of which are in the amendments as impairments, why, just on the face of it, isn't that person a disabled person under the Act?
Your Honor, fly above...
Even without regard to morbidity.
Your Honor, fly above agrees that with respect to a major life activity, that the plaintiffs in this case have alleged that it affected a major life activity of walking, standing, breathing. However, that does not negate the fact that an ADA impairment is required. That impairment should be satisfied by a relatively easy pleading standard just for the plaintiffs to come forward and say that their obesity is accompanied by diabetes, liver failure, heart disease.
Where does that come from, that it has to be accompanied by something?
Your Honor, with respect to...
Sixth Circuit case?
That is the Sixth Circuit case, but also with respect to some of the newer case law after 2008. For example, a very recent case in the Eastern District, Louisiana, as recently as February 29th, 2012, did hold in favor of the EEOC's position that morbid obesity is a per se impairment. But...
Counsel, we're not bound by those lower court opinions, are we?
That's correct.
So tell us why we should decide that those lower courts are correct.
Actually, in this case, Your Honor, the lower courts with respect to the Sixth Circuit and the Second Circuit are correct, that require an underlying condition.
Why is that the better result?
Absolutely. Chief Justice, that's a better result because it's a relatively low pleading standard for the plaintiffs in this case to meet, or in any future case, because it allows for the fact that the underlying concern of medical doctors is with respect to the health conditions that obesity is related to.
So the health condition has to be a result of the obesity. Could you have it the other way around? Could the health condition cause the obesity and satisfy your standard?
That's precisely the rule that Fly Above is putting forth, that there is an underlying condition or a resultant condition.
But doesn't the statutory text talk about being regarded as having an impairment? Isn't that quite general and seemingly liberal standard?
Justice Liebman, with respect to the regarded as prong, that is the plaintiff's alternative argument. And in this case, Fly Above suggests that the alternative argument fails as well, because the plaintiffs in this case have merely alleged that the employer stated that it did not want to make a regular use of forklifts for lazy employees. Laziness is not an impairment. It's not an actual impairment. It's not a perceived impairment. Laziness is merely encouraging employees to walk across the warehouse floor, to use the forklifts as a regular, accustomed policy that the employer put forth, that sometimes these plaintiffs could use the forklifts. They could use the forklifts for heavy boxes. But in this case, the employees come forth suggesting that they should be allowed to use these forklifts on a regular basis. That regular basis would be completely inappropriate in this case, and this court should not find that the laziness statement or that the complainer statement is enough to suggest a regarded as claim.
They have to actually say you can't use the forklift because you're obese? I mean, isn't there something beyond just what the actual words used are?
No, Justice Liebman. A good example is provided in EEOC versus Texas Bus Lines Incorporated in 1996. And in that case, a regarded as claim was found where an employee went to a medical appointment with the employer's doctor. In that case, the doctor for the employee watched an employee rise in the waiting room, walk across the waiting room to meet with the doctor, and the doctor's perception of the employee's slow movement and his immediate assessment that that employee was obese, that was enough for a regarded as claim. Moreover, even after 2008, another case, the Eastern District case of Louisiana that we were speaking about earlier, was a similar situation where the employer's doctor regarded that employee as being obese. So in that case, it was the perceptions of the medical doctors provided for by the employers that related to the fact that the underlying statements by the employer were connected to the perception that the obesity was the regarded as disability in that case.
Counsel, that case notwithstanding, isn't it true that sometimes what happens is instead of saying you're fat, they say lazy because a lot of people think fat and lazy go together, and that while he didn't say, well, you can't do it because you're fat, that was the underlying subtext. Do you follow up on the question? Do you really have to say fat or obese?
I do follow your question, Justice Ellis, and unfortunately our society at times does equate the word lazy with obesity. However, in this case, the employer was merely concerned that creating a wide policy for all employees, that these employees could use forklifts on a regular basis, would create such a standard that anyone would come forward, obese or not, to request regular use of the forklift. Even the plaintiffs in this case concede the fact that this employer on a fairly regular basis allowed the employees to use the forklift for heavy boxes. However, the plaintiffs in this case are actually alleging that sometimes merely walking from the computer terminals to lift light boxes onto the shelf, which would certainly be part of their job description, would be unreasonable.
The facts are a little different. I mean, they let employees use the forklifts if they had a physical disability. They had, for instance, had some kind of surgery on their legs or had a back problem that was in the process. They let them use it, but not just some. I mean, they let them use it if they had a physical, but they didn't apply that same rule to somebody who was morbidly obese. I mean, the plaintiff in this case, by any definition, is morbidly obese.
That's correct, Your Honor.
And they wouldn't afford her the same, let's call it reasonable accommodation. That's, I think, is a good phrase. To her that they allowed to people who had back problems, surgery, recovering from surgery, or other kinds of physical problems.
You're certainly correct, Your Honor, that Ms. Costanza is indeed obese in this case. However, Ms. Costanza, with her request to use the forklifts, she had completed this job on a regular basis with no complaints against her work ethic or no complaints against her finishing things on time. She was terminated in this case, however, because she started to fail to meet quotas. That was why the other 30 plaintiffs were terminated as well.
She gained 100 pounds over a period of her employment. She was very heavy when she started, and she gained 100 pounds in the, I think it was 10 years she worked there.
That's correct.
And Why shouldn't she get a reasonable accommodation? If she has trouble breathing, trouble lifting, trouble walking, why wouldn't the same reasonable accommodation that you give to somebody who has a bad back, for instance, and can't do those same things because of the bad back, why don't you give the same?
Respectfully,
What in the law would justify not giving her the same?
Respectfully, Your Honor, because with obesity in this case versus what the record shows as plaintiffs, or excuse me, not plaintiffs, other employees who had requested the use of these forklifts, they had medical complaints, they may have had doctor's notes, they may have had a chronic condition. In this case, the plaintiffs come forward suggesting that aches and pains, backaches and pains,
Let's talk just about her, not about the group that joined later. But in the beginning, she asked alone. She was part of no group. She went and asked and said, could I use the forklift, for just other purposes, the way you allow somebody with a bad back to do it. What basis was there for turning that down? Forget the group argument. Just that one person they turned down before they ever got to the petition.
Certainly, Your Honor. And with respect to Ms. Costanza, the reason that the employer would have turned that particular request down is because when Ms. Costanza was making that request, it could create such a broad policy concern for the employer to provide on a regular basis for all employees to use the forklifts. So although it's an unfortunate situation with Ms. Costanza, the employer...
Why isn't obesity a bright line standard?
In this case, Chief Justice, with respect to cases that come before this court later or lower courts later, the concern that I mentioned about an NFL player, for example, who is 5'10".
Sumo wrestler.
But counsel, isn't the opposite also true? Use the example of the athlete to show that you can be medically obese and not impaired. Isn't the opposite also true, that you can be medically obese and impaired? And yet what you're asking for is a categorical exclusion based on obesity. So I'd ask the following questions. You've conceded that Ms. Costanza was medically obese, correct?
Correct.
And you would acknowledge that obesity is recognized medically as a disease?
No, Your Honor, I would not.
So you would
not
dispute the
universally.
American Medical Association classification of obesity as a disease?
Yes, Your Honor, I would. And the reason that I would dispute that, Justice Firestone, is because the Centers for Disease Control and Prevention, which both lower courts relied on for its classification of the body mass index, the CDC does not show that obesity is a disease, disorder, illness. For example, the CDC does recognize accompanying diseases that are related at times to obesity as underlying conditions or symptomatic conditions related to obesity, such as diabetes. However, the CDC does not recognize obesity in and of itself as a disability or a condition or a disorder.
I didn't ask disability, I said disease. It's medically significant. All I'm saying, isn't it conceivable that obesity can impair basic life functions?
It is conceivable,
Factually.
Your Honor.
Okay, so then final question, why are you denying a factual inquiry on that point?
Yes, Your Honor. The reason, with respect to Justice Firestone's concerns and the Chief Justice's earlier concerns, that Fly Above is putting forth the requirement that an accompanying physiological condition or disorder needs to be pled, is that that is not such a severe or difficult standard for the plaintiffs in this case to allege. All these plaintiffs need to allege is that their obesity is accompanied by diabetes, heart disease. If the per se rule suggested by the EEOC is formed on the basis that morbid obesity is necessarily connected to these conditions, that's not a hard requirement to meet.
The statute doesn't refer to disease. It refers to a physical or mental impairment.
That's correct.
That substantially limits, et cetera, et cetera.
That's correct, Your Honor. And an
Can
impairment.
anybody say that someone who's 200 pounds overweight doesn't have an impairment?
Respectfully, Your Honor, an impairment is also, I see that my time has expired. May I briefly finish answering your question, Justice Irenas? With respect to an...
You may.
Thank you, Your Honor. With respect to the impairment issue, it's defined as a physiological condition or disorder. That's where I was referring to the disorder or condition, because the CFR provided by the EEOC defines an impairment in such a way. Thank you, Your Honors.
Madam Chief Justice, may I proceed?
You may.
Good afternoon, Your Honors. Madam Chief Justice, and may it please the Court. My name is Lauren Nennick, and I also represent petitioner Fly Above Warehouses in this proceeding. Your Honors, today, Fly Above Warehouses urges this Court to affirm the 13th Circuit and hold that the class action waiver is enforceable for two reasons. First, that class action waiver was freely bargained for and clearly and unmistakably waives respondents' right to class action arbitration. And two, a judicial nullification of a perfectly enforceable collective bargaining agreement provision contravenes the purposes underlying collective bargaining of the National Labor and Relations Act. Your Honors, this Court in AT&T Mobility versus Concepcion stated that the purposes under the FAA is to ensure that private arbitration agreements are enforced according to their terms.
If a private arbitration agreement had something in it that was a violation of the criminal law, I mean, a court wouldn't enforce a contract whether it was collectively bargained or bargained between two businesses, however it was arrived at, if it had a violation of the law, right?
That is correct, Justice Meisberg.
Didn't the court below find that the laws protecting individuals under the ADA, didn't the court below find that the contract impaired the effective enforcement of those laws, that it in fact kept people from being able to exercise their rights under those laws?
It did, Justice Meisberg, but their reliance on two cases in particular were misplaced. The court relied in reference to their Section 7 rights on the National Labor Relations Board recent administrative finding of D.R. Horton versus Michael Kuda. And that case is distinguishable from our case because in that case they were dealing with a employer-employee adhesion policy. And in this case, we are dealing with a union that bargained freely on their behalf.
Suppose the union waived their rights under the ADA. Would you be asking us to enforce that contract? It waived their rights?
No, Justice Meisberg.
Well, then, but didn't the court effectively below find that this contract partially waived their rights?
The court below found that they partially waived their rights.
And we should enforce that?
Yes, Your Honor, you should, because waiving a right to a judicial forum, as this court held in 14 Penn Plaza versus Pyatt, doesn't waive a right under the statute. And in this case,
Well,
they
but
are...
that's not what the court below... The court below found that it wasn't just that the waiver of the judicial forum or the waiver of the class action form was a effective limitation on the ability of individuals to exercise their rights under the substantive provisions of the statute.
Yes, they did, Your Honor, and they relied on the cost prohibition, and they relied on this court's finding in Green Tree Financial versus Randolph, where in that case...
We couldn't make, the circuit said they couldn't determine what the financial impact was of the waiver, whether it was really too expensive or not. They said, we don't really know.
Correct, Your Honor.
They said?
Yes, that's...
Do we know? Can we now say that it would be just too expensive for an individual to pay their share of the arbitration costs on an individual case? Do we know enough to say that?
No, we don't, Justice Arenas, and that goes to the heart of the issue that the court was looking at in Green Tree Financial, is that they stated that the record was too speculative as to whether or not the plaintiffs in that case would be ineffectively unable to vindicate their rights, and that is exactly the issue we have here. We
could give the court below guidance on the question. Suppose we were to remand to the court and ask the court, direct the court, to take evidence on the question of the effect of the cost of the arbitration on the ability of the individuals to secure their rights under this law. Should we give some guidance to the court below on what to do if the court finds that the cost is prohibitively high? And shouldn't we tell the court below, what should we tell the court below it should do if the cost is prohibitively high?
Well, Your Honor, you could establish that the claimant in this case bring forth some evidence that she would be unable to bear the cost of arbitration. And the Seventh Circuit did exactly that in the case of Livingston versus Associates Financial, where they stated you can't give a bare assertion that arbitration will cost up to $2,000 per day. That simply is not enough. So what the plaintiff in this case should have done when she was wanting to compel class arbitration, which this court in Greentree Financial stated, they have to come forth with evidence when they are requesting arbitration. And that time is now. And the plaintiff in this case did not bring forth evidence to show that she was going to be unable to bear those costs. The record is silent, Your Honors, as to whether there is any other financial means for her to get this $2,000.
Would you agree that if at some level the costs were prohibitive, in other words, it would discourage or make parties unable to individually arbitrate their claims, that we would not enforce that? We would not enforce that arbitration if that were the case.
Yes, Your Honor, that would be freely within the law and freely within your power to invalidate that provision, because that goes directly to Section 2 of the FAA that gives the courts the ability to save the clause if they are illegal or inequitable. But, Your Honors, there's also an equitable concern here for the employer who bargained in good faith, that went through significant negotiations with this union, it was the union who bargained away their right to class action. In fact, Your Honors, on note 4 of page 5 of the record, the employees in this case actually brought a fair representation claim in this litigation against their union for waiving their right to class arbitration. But the plaintiffs in this case elected to drop that in exchange to be able to go forward with vindicating their rights on an individual basis.
But isn't that also related to the fact that you haven't brought the union into this case? And how do you compel arbitration if you don't have the party to the arbitration agreement in the lawsuit? I mean, the individual employees that are in this lawsuit are not themselves party to this agreement.
That is correct, Justice Lehman, but as this court recognized in 14 Penn Plaza, that there is no delineation as to whether the union representatives or the employees are the ones being affected by the provisions in the collective bargaining agreement.
Issue, though. I mean, it may ultimately be that there's no difference, but assuming you have the right parties in the litigation, do you have the necessary party in this litigation? Seems to me you don't.
We do have the necessary parties.
Well, the necessary party seems to me to be the union here. The union is the party that entered into this arbitration agreement with the company.
That is correct, Your Honor, but it is well understood and well established that in all collective bargaining agreements that these individuals are submitting to the union to bargain for them on their behalf. So when the collective bargaining agreement is effectively signed and put into effect, these employees know very well what their rights are under the agreement. And when an agreement states that all individual claims shall be subject to the arbitration and grievance procedure, and the arbitrator shall apply the appropriate law to individual claims only, and shall have no authority to hear class action claims, that is very clear.
Is that a clear and unmistakable waiver of employee rights? It says what the arbitrator shall have authority to do, but is it really a clear and unmistakable waiver of employees' rights to proceed on a group basis? Because what you're arguing is waived here is not only the right to proceed on a group basis in this arbitration, but before the court.
It is, Your Honor, and the parties in this case in the district court and the appellate court below agreed that the issue is not whether this should go to arbitration. The judicial form has effectively been waived. But it is clear if you read those two clauses in tandem, since the parties agree that they must go forward to arbitration to submit their grievances, and the arbitrator shall only have the power to hear individual claims and shall have no authority to hear class action claims, reading those provisions in tandem, it is a reasonable interpretation for this court to find that that is a clear waiver of their rights to class arbitration.
In this case, the employees are precluded not only allegedly from going to court, but from proceeding on a class basis. And the union, it seems to me, has deprived them of their right to proceed with the union's representation in the arbitral forum. So shouldn't that relieve them of any obligation to proceed solely in arbitration, because the union itself is not willing to pursue the case on their behalf, even on an individual basis?
No, it shouldn't, Justice Lehman, because there are many concerns other than just an employee's rights to vindicate their statutory claims, which they may well do on an individual basis, which has been acknowledged by the union and the company. There are equitable concerns for the company in this case. When a company bargains collectively with an employer, they enter into the agreement and have a sense of certainty, a certainty that they know very well how this is going to play out if there is an issue. And if there is an issue of whether something has been clear and unmistakably waived, they can go to the agreement and see that they agreed that the arbitrator shall have the power to hear only individual claims. So that strips the company's certainty when they go through a collective bargaining process. That would undermine the process of collective bargaining, since the company very may well have given a little and the union to get a little. That's the underlying process of
What is
collective
it that
bargaining.
the company gets out of this that you're saying that they bargained for?
Justice Buckler,
Certainty of what?
the certainty of knowing that the things that they bargained for and agreed to have been memorialized in this collective bargaining agreement.
But how does it benefit the employer not to have to arbitrate on a class basis?
That's a good point, Justice Buckler. And Justice Scalia actually noted in his opinion of Concepcion that due to the amount of class arbitration claims out there were 283 as of 2009. 121 were still active, and none have been adjudicated on the merits. The average length of those class arbitration claims lasted over 600 days. That is a significant amount of time where an advocacy group called the Federal Mediation and Conciliation Service recently did a study in 2011 that noted that the average bilateral arbitration lasted 3.9 days. So there is a significant concern about time here, Your Honor. And also the class in the record has not been reflected that it has been certified or not. So they have to go ahead and certify the class, decide whether there are the commonalities within this class. Takes significantly more time, and that is exactly what Flyabove, when bargaining for an individual claims process, agreed to. So that would significantly alter what the parties, both parties, the union and Flyabove, intended.
Aren't they actually essentially bargaining for based on the knowledge that individual employees will not be able to bring these claims on their own? And so they're essentially bargaining for not having to have any liability with respect to these claims?
No, Your Honor. Flyabove is not simply using the individual claims provision as what some refer to as a litigation tactic. Flyabove has no idea what these individuals' personal financial situations are. All we have in the record is that some of the employees make between $10 and $14 an hour. But to suggest that Flyabove, speculated as to the employees' financial situations when they were bargaining is without merit, because there's nothing in the record that reflects any bad faith.
Counsel, which brings me back to the question of the practical question of what should the district court have done in this instance. It seems that the bargaining took place when nobody knew for sure what the individuals would be able to do, and yet it does appear that to the extent that the individuals don't have the financial capacity, it would infringe their rights to proceed. And so should the district court have just ordered individual arbitration, or should it have said, I cannot decide this unless we answer the questions which you say are unanswered?
That's correct. That's correct, Justice Ellis. If they were going to rule that individual arbitration should not have proceeded, they should have decided that more facts were needed, but they did not, and they took exactly what they had on the record, the bare assertion that arbitration would cost $2,000 a day and merely the wages. And in this,
what's wrong with making the assertion? Are you saying this is a failure of pleading, that if they say they could not afford it, should they have done a financial statement? I mean, what more should they have done?
well, Justice Ellis, as the Seventh Circuit looked at the same kind of case, and in Henri American, Your Honor, I see my time is up. May I please briefly address this question? In cases like Henri American Express Merchants litigation, those cases where they held that the vindication of statutory rights had been precluded, all of those cases had affidavits that showed exactly what the potential recovery was going to be and the exact costs. And that, in this case, Ms. Costanza and the other plaintiffs very well could have attached a personal affidavit to show that they themselves would not be able to bear those costs.
Do you want to throw them out of court at the earliest stage? Shouldn't we be finding a way to answer those questions at this early stage in the litigation, a motion to dismiss before even an answer? Shouldn't we find a way to answer the questions that are unanswered and that would inform our decision?
No, Your Honor, you shouldn't, because Ms. Costanza had a fair opportunity to disclose that she would not be able to shoulder the costs. And this court in Greentree specifically stated that it was their burden to show that they would not be able to shoulder those costs when they were filing a motion to compel arbitration. Ms. Costanza and the other plaintiffs failed in meeting that burden. And for these reasons, this court should affirm the 13th Circuit and hold that the class action waiver is enforceable. Thank you.
Good afternoon, Chief Justice, Associate Justices, may it please the Court. My name is Arthur Sesgin. I represent Mary Lou Costanza and the class of respondents in this matter. My co-counsel, Benjamin Sampson, will be arguing that the decision to compel individual arbitration should be overturned. I will be arguing that the motion to dismiss was properly denied because obesity is a disability under the ADA. Your Honors, obesity is a serious condition that leads to many life-threatening illnesses. As such, the lower courts were correct to find that obesity per se and obesity in this case is a disability under the ADA for the following two reasons. Our client did have a physical impairment that was substantially limiting, and secondly, as the lower courts also found, Mary Lou Costanza was regarded and perceived as being disabled. Your Honor, substantial time was spent on the physiological...
You need both of those, right?
That's correct, Your Honor. We only need one of those under the ADA. It's either a physical impairment that's substantially limiting or being regarded as being disabled, whether or not there is a substantially limiting impairment. Opposing counsel spent significant time arguing the physical impairment prong. As we could see, there is some ambiguity under this, in defining this prong. When there is ambiguity, deference should be given to the administrative agency that's in charge of enforcing the ADA under Chevron. And that would...
What would we be deferring to in this instance? Their position they've taken in court?
No, Chief Justice. No, Justice Liebman. Deference should be given to the EEOC in this case, which is an administrative agency.
But what action? I mean, what is it, a regulation or guideline of the EEOC we should be deferring to?
That's correct. The EEOC has held that most physical characteristics, such as weight and height, hair color, or eye color, typically will not be considered physical impairments for purpose of ADA. However, they've also mentioned that any deviations in weight and height that are outside of the normal range, which obesity is, does not require an underlying physiological condition.
Why should we defer? I mean, who wrote that? Who decided that? A bunch of bureaucrats? Why should we defer to that? We're as smart as they are.
That's correct, and this court isn't bound to defer to the EEOC. However, typically under Chevron, when an administrative agency's interpretation is reasonable and makes sense, then deference is proper.
But isn't that a medical, the particular issue that you're asking this court to defer to the EEOC on is essentially a medical decision. It's not like a determination about workplace conditions, which they might be expert in. Is the EEOC an expert in medical issues?
No, they certainly are not. However, they've realized that in case of obesity specifically, given that the science behind it is still somewhat unclear, and each day there's new discoveries about what could cause obesity and the resultant conditions of obesity, whether it's diabetes, heart disease, thyroid disorders, or hypertension, for example, they've realized that. And because of that, they've said that, for any deviations outside of the normal range, it would be, in essence, not appropriate to require an underlying physiological condition.
Counsel, you've said several times outside the normal range. Are we talking about national or local? And if we're going to say outside the normal range, how do we avoid the disaster that the employer is talking about? It's like in our neighborhood, everybody seems to be overweight. I mean, in New York, a lot of people are overweight. I mean, is there any way for me to know where this stops? I mean, some people might consider me outside the norm also. I don't consider myself obese, though.
Justice Ellis, unfortunately, the term normal has not been defined. In fact, on its face, in the statute, is actually in quotation marks for that very reason, because it's hard to determine what is normal. Again, it's a relative term, and what's normal in one state or one company might not be normal in another. That's why the ADA actually requires additional steps for one to be entitled to relief under the ADA. For example, the first prong is that there's actual qualified disability, which is where we are now. Second, an individual must demonstrate that he or she is a qualified individual. And lastly, that individual must demonstrate that an adverse employment action was taken on account of that disability. So by holding that obesity with or without an underlying cause is a disability, it doesn't necessarily lead to anybody bringing forward a claim, whether or not they're in the normal range. There would have to be additional discovery conducted, additional steps taken to see whether or not that individual...
And whose definition of obesity do you think we should use?
Well, the definition in this case is pursuant to the Centers for Disease Control. In fact, even the American Medical Association agrees that obesity is simply a body mass index above 30. Now, the way that's calculated differs depending on the agency whose interpretation is adopted. For example, the Centers for Disease Control simply look at weight and height. However, the American Medical Association also factors in muscle mass and the amount of fat content an individual has. So it might be a more accurate reading.
Counsel, can we go back to the question? You're asking us to make a categorical determination about whether a condition is a disability based in part in deference to the EEOC. And I'm still confused about to what exactly we're deferring, because the pre-amendment regulations said, quote, except in rare circumstances, obesity is not considered a disabling impairment. That's the EEOC. And in its post-amendment regulations, there's not a single word about obesity. And so given the regulatory silence, I don't understand how we can actually defer to the commission on this.
Well, the EEOC's position has actually evolved. For example, in EEOC versus Resources for Human Development, they have actually expressly stated that obesity doesn't require an underlying physiological condition to be considered an impairment.
That's a litigation position, correct?
Well, that's the administration's position. Another case where it was the litigation position would be EEOC versus BAE. In that case, as Justice, you referred to, it was the litigation position. Nonetheless, it is their position that...
And yet the regulations are silent.
That's what you're asking us to defer to a litigation position. At the end of the day, there's nothing in the regulation, but since January 1st, 2009, they have in litigation, in a variety of litigations, taken the position that obesity is a disability. So you're asking us to defer to a position that they took in litigation. Isn't that what it comes down to?
That's correct, Justice. Given how unclear the physical impairment and physiological condition elements are, this court can adopt the EEOC's position, or they could actually draw a bright line rule themselves and start distinguishing between obesity per se and maybe morbid obesity. As long as our clients are protected in this case, that's all we could really ask for.
Authority for the notion that Chevron type of deference should be given to a litigation position, even a consistent litigation position?
Unfortunately, there's no authority readily available as far as whether Chevron should be.
And there's an important difference, isn't there? Regulations are adopted according to a process. There's a notice and comment period, none of which applies to a litigation position. So isn't there a reason to have deference to regulation that would not apply to a litigation position?
That's correct as well, Justice. However, in this case, given that, again, there is so much uncertainty in defining the physiological impairment, and for the most part, the EEOC's interpretation does make sense given the unknown nature of obesity and its harmful effects on those affected by obesity, hopefully this court will also adopt the EEOC's position. Your Honor's opposing counsel are...
Adopt the position? What position?
Or follow their interpretation.
Remember, in a litigation case, you're taking a specific person. You're dealing with a specific individual with all the specifics of that person. When you make a regulation, it's designed to apply to everybody. And it's in that context that there may be Chevron deference. There is Chevron deference. But in a litigation, unless you really knew the facts of the case, because there may be a case where someone is 600 pounds and has diabetes and they take a position, and then you may have a case with every case will have a different set of facts.
That's correct. It does come down to certain facts of the given case, Your Honor. However, going back to the initial point that because obesity is an amorphous condition and the EEOC realizes that, this court will hopefully follow their interpretation of what is a physiological impairment and when it's required. In the case of obesity, because it's a weight range outside of the normal range, that an underlying condition isn't required. Opposing counsel also said that we have an alleged underlying physiological condition. If that's the case, at the very least, we would ask for this court to remand so that we would allege an underlying physiological condition, and the motion to dismiss would still be properly denied.
Can I ask about your alternative argument, the regarded as having an impairment? Well, first of all, the petitioner claims that you haven't adequately pled that, so I'd like you to address that. But the second question is, would this mean, for example, that if an employer believes that someone is too thin to be able to carry out jobs that have physical requirements because they think they're just not strong enough, would that mean that being too thin is a disability?
No, Your Honor. To go to your second question regarding the thin, again, for something to be considered disability, an individual must demonstrate that he or she is first qualified. So in that individual's situation, if his or her thinness is actually a hindrance to his or her performance of the job duties, then it will not be a disability, and that person will not be entitled to relief under the ADA. And employers are, as Tuddy v. United Airlines stated, employers can hire individuals based on certain preferences. So in that case, if it's a job that requires an extra amount of or strenuous amount of working, lifting or bending or carrying, then the employer is well within his or her right to hire an individual that fits those categories and with the required weight or height, whatever it might be. And to go back to your initial point as far as the regarded as, and this ties back to Justice Ellis's, the lazy comment that you brought up, here our clients were perceived and regarded as being disabled. The lazy comment, as opposing counsel argued, can mean a number of different things. However, Your Honors, it's very unlikely that an employer will say that we are terminating you or I think you are this because of a protected class. Opposing counsel argued that lazy is not an impairment. He is absolutely correct. Lazy is not an impairment. In this case, lazy is pretext, Your Honors. Supervisor Kramer referred to our clients as being lazy despite almost a decade of committed service because they asked to use the forklift more. Opposing counsel also incorrectly stated that our client wanted to use a forklift on a regular basis. However, as the record on page 4 provides, our client wanted to use the forklift more frequently if and when her pains were acting up.
Have you alleged anything, any facts beyond the lazy comment to suggest an animus toward obesity?
Yes, Your Honor, we have, and that would be my second point, is that by looking at the close temporal proximity between the petition, which was on November 22nd, and their subsequent termination on December 1st, the 31 individuals that were obese, and only those individuals were terminated. Again, under Twomey and Iqbal, which simply requires that there be enough facts to state a claim for relief that's plausible on its face. In this case, the temporal proximity, the termination does satisfy that, given that only those employees were terminated 8 days after signing the petition.
Counsel, if your clients are not disabled under the first prong, but somehow are under the third only, what remedy would you be seeking?
The remedy in this case, Your Honors, as the opposing counsel will argue, would be back pay, compensatory damages, punitive damages, and possibly an injunction to bring them back to work as well. Again, our client, as the record on page 3 provides, is a single mother, age 43 with 2 kids. She and those similarly situated as her have been out of a job for 2 years, Your Honors, which is why this court should find that obesity is a disability under the ADA, and the 12B6 motion brought by petitioners was properly denied. Thank you for your time, Your Honors.
May it please the Court. Good afternoon, Your Honors. My name is Benjamin Sampson, and I will be speaking on behalf of Mary Lou Costanza and the 30 other aggrieved claimants, collectively referred to as the respondents. A class action is not merely a method or a procedure, but rather it provides individuals with a voice that would otherwise not be heard. And for the two following reasons, this Court should reverse the 13th Circuit's decision to compel individual arbitration. First, a class action waiver interferes with Section 7 rights under the National Labor Relations Act. Second, enforcing a class action waiver would effectively preclude these individuals.
Counsel, if the union had agreed to a no-strike clause, strikes are protected activity under Section 7.
Yes, Your Honors.
And such clauses are lawful.
Yes, Your Honor.
In a collective. Why is this different from that?
Well, yes, Your Honors. In fact, this court recognized in the Steelworkers Trilogy that the right to strike can be bargained away as a quid pro quo for the arbitral forum. It's this type of activity that actually promotes the free flow of commerce. But here, we're not dealing with that type of right. In fact, the National Labor Relations Board has actually emphasized the type of rights that can be bargained away, like the right to strike or the right to cross a picket line and other economic rights. Here, we're not dealing with an economic right. This is a due process right.
So in the courts, there are thousands of cases brought on an individual basis under the ADA. Thousands of them, all over the country. And people, apparently, individuals have no problem getting a case. Is there something about the arbitral forum that makes it prohibitive when in a court they do it all the time? They go individually.
Well, yes, Your Honors. In fact, the respondents here would love to proceed within the arbitral forum, yet they need to do so as a class based on the actual provisions.
My question is, they do it, it's economically viable to bring individual cases under the ADA in court. They do it thousands of times, all the time. What is it about the arbitration forum that makes it prohibitive when it's done all the time in the courts, individual cases, one by one?
Well, here, Your Honors, it is prohibitive because of the cost. And if you look to page 4 and 5 of the record, well, here, Your Honors, it's clear from the record that there is a fee-splitting provision within this actual contract.
Fee split, what fees?
Well, the fee-splitting provision would, the respondents have actually emphasized, could probably be dictated by the American Arbitration Association.
They have the power under their rules, do they not, based on the result, to award counsel fees, to award costs of arbitration?
That's absolutely true, Your Honors, but the problem is that Mary Lou Costanza is not going to risk and gamble these circumstances so that she can proceed with what is a speculative outcome within these circumstances. And the Sixth Circuit has recognized in Morrison versus Circuit City Stores that if you force an individual to look at the potential recovery, you'd have a situation where you wouldn't have a few individual claims, you would effectively have 0 claims. And the petitioner has noted that there is some certainty with these contractual terms.
What are the costs you're talking about?
The cost, as cited in the record on page 15, would be...
You're talking about paying half of the defendant's legal fees?
Well, no, Your Honors. Half of the arbitral cost for the actual judge, the arbitrator himself. Whereas in the judicial forum,
But can't the arbitrator allocate that based on his result as to who pays that and in what percentage?
Well, yes, Your Honors, it's possible, but from the actual inception of the arbitral process, Mary Lou Costanza would have to she would have to split in the fees for the arbitrator, which here would be around $2,000.
Where do you get that from?
Page 15 of the record, Your Honor, it specifically states that to hire an arbitrator for these specific circumstances...
That's the ultimate cost, but the allocation of who pays for that cost, isn't that up to the arbitrator based on the outcome of the case?
Well, not under the petitioner's theory, Your Honor. Here, the contractual terms as they've posed have to be enforced within these circumstances. And if that's the case, according to page 4 in the record, Mary Lou Costanza would have to share in these costs.
Isn't that ambiguous, though? Isn't that what we don't know in this case is what the real economic impact of proceeding one by one in arbitration? We don't really know that, do we?
Well, yes, Your Honors. There's a lot of speculation and ambiguity with this actual contractual provision. In fact, if you turn your attention to page 5 of the record, this is not the clear and unmistakable standard that this court has emphasized in the case of Pyatt. In those circumstances, in 2009, this court pointed out that that article provision that said all disputes must proceed within the arbitral forum was clear and unmistakable. Here, according to its language, it says all such individual suits must proceed within the arbitral.
What about a different ambiguity? The ambiguity being what it was really going to cost an individual to proceed, particularly if that individual won the case.
Oh, no, Your Honors. Here, there is no ambiguity that Mary Lou Costanza would be prohibited from bringing this claim within the arbitral forum. In fact, as the petitioners have correctly noted, Greentree Financial versus Randolph set that standard. This court in 2000 stated that showing that there would be a risk that you would be saddled with costs does not satisfy the burden. Here, there is plenty of evidence to show that Mary Lou Costanza would not be able to bring this cause. On page 3 of the record, as opposed to what the petitioners have framed her maybe as a sumo wrestler or a wealthy NFL player, she is in fact a 43-year-old single mother raising 2 teenage sons. She makes $14 per hour, as emphasized in the record on page 29. Congratulations, Your Honors. You officially know more about these employees than Fly Above Warehouses, who conceded that they were not aware of how much money Mary Lou Costanza or these...
I have a practical question for you. You keep talking about how they cannot afford to do this. And while if the employer is going to do 30 individual proceedings, that might be true. But isn't the reality of a situation like this is that the employer is going to do maybe 1 or 2 and see how it works out? And that indeed, if these employees want to find out if they have a good case, they could pool their resources, try the first couple of cases, and then they know what the result's going to be, because they all have the same claim. Isn't that true?
Yes, Your Honors, they are all similarly situated, but here they're actually trying to bring a pattern or practice claim, which takes on a whole different form. And this is also another example.
But again, if it's a pattern or practice, they have the same claim. If they're going to meet the requirements of a class action, the individual complaint they have about the employer is that they're obese and they're not being accommodated. If you're right on the law, doesn't that just mean that 1 or 2 of them have to bring it? Because the employer isn't going to keep bringing these cases if it's going to lose them. And once the employees know that they're going to win, that changes the dynamic of what the risk is, doesn't it?
Well, Your Honors, it does change the dynamic of the risk, but it doesn't change the fact that concerted activity is actually being infringed upon in these circumstances.
That's only true if you're not going to be able to vindicate those rights.
Well, no, Your Honors, absolutely not. Even if they were able to afford the cost of the arbitral process with this $27,000 price tag, they still would be having their concerted activity infringed upon, as emphasized in Section 7 of the National Labor Relations Act.
So you don't think we need to find out how much this is going to cost?
Well, Your Honors, here it is certain from the record that it will cost too much for these individuals to proceed within the arbitral forum. That has been satisfied by the Greentree Financial versus Randolph standard emphasized by this court. And to proceed back to the actual concerted activity problem, In re D.R. Horton pointed out that Federal Rule Civil Procedure 23 can act as concerted activity.
But let's talk about Horton for a moment. That clearly was not a collectively bargained agreement. That
Yes, Your Honor.
was essentially what the board found there imposed as a condition of employment. Isn't there a substantive difference between an agreement with a waiver like this that's part of a collectively bargained agreement where there's been give and take and quid pro quo, particularly in light of this court's well-established precedent that employers can't enter into separate agreements with employees, that the collective bargaining agreement and the collective bargaining representative are an exclusive representative?
Well, Your Honors, to actually go to the actual quid pro quo that you mentioned earlier, there is no quid pro quo within this circumstance. And In re D.R. Horton, well, Your Honors, here it's speculative from the record whether anything was gained from this actual class action waiver for Mary Lou Costanza or these 30 aggrieved claimants.
You can say that about any provision in a labor contract. There's 100 provisions in a labor contract. Who knows?
Don't we assume there's been give and take for the agreement as a whole?
Well, Your Honors, you posed somewhat similar questions. I think in answering the Associate Justice Liebman's question, I can answer it and clarify here. Your Honors, here, unlike other provisions that are oftentimes contracted away, like the right to strike, Steelworkers Trilogy noted that the right to strike is the quid pro quo to proceed within the arbitral forum. Here, there's nothing from the record to show that Mary Lou Costanza or the 30 aggrieved claimants actually did receive a quid pro quo. And In re D.R. Horton noted that it needs to have that in order for that contractual provision to actually bargain away these particular rights. And looking at the actual article provision in and of itself, it's a lose-lose for the employer within these circumstances. Either if it is clear and unmistakable, it violates In re D.R. Horton. If it's not clear and unmistakable, it violates 14 Penn Plaza LLC versus Pyatt. And the reason it is not clear and unmistakable is because it does not say where class actions are to proceed within these current matters. And if it does say that the judicial forum is gone and that the arbitral forum is the only remedy, it is emphasized within the case of In re D.R. Horton that you cannot basically say that a class action cannot proceed in both the arbitral or the judicial forum, because that is automatically a violation of Section 7 under the National Labor Relations Act.
Let me ask you this. So suppose you had a judicial forum available and the judicial forum imposed its regular class tests. Would Section 7, as interpreted by D.R. Horton, overcome the ability of a court to keep a class from forming because of the types of rules that a court would apply?
Well, Your Honors, here, In re D.R. Horton has noted that if the judicial forum is still open, there is not a violation of Section 7. But here,
Why not?
actually,
If the court could say, well, we're not going to let you proceed as a class because you don't satisfy certain standards that we have for a class.
Well,
Does the court get the authority to do that if the law says they've got a inchoate right to proceed as a class?
Well, Your Honors, the reason that wouldn't be a problem within those circumstances is because the judicial forum would have decided the issue. Here, the judicial forum has they do not hear whatsoever the actual issue, and neither will the arbitral forum because the costs are too prohibitive. This goes back to a case
You're
that this...
saying that D.R. Horton, as it interprets the National Labor Relations Act, gives an inviolate right to proceed in a class action, but a court can ignore that.
Yes, Your Honor.
By applying certain rules.
Yes, Your Honors. In fact, this court in 2011 denied a class certification in Walmart Incorporated versus Dukes.
How does the court get the authority to violate that law?
Well, Your Honors, the reason would be is if you were to proceed within the judicial forum and maybe that didn't actually satisfy some of the requirements like class certification.
Why do they have to satisfy any requirement? Why does a court have the ability to impose requirements?
Well, Your Honors, the requirements are actually emphasized in Federal Rule of Civil Procedure 23, which Congress enacted, and it's just a procedural basis. The court would be interpreting those rules, and that's a limitation on whether you can proceed within a class action. Here, we can't even get to the commonality questions because we haven't even gotten to the discovery phase. But
has your client filed an unfair labor practice charge against the union, claiming that it had no authority to waive these rights?
Well, here, Your Honors, they have filed an Americans with Disabilities Act claim because they do find that they were unfairly discriminated against because they are obese and therefore satisfy the disability requirements. Here, they all 31 sought out a petition, as indicated on page 4 of the record, circulating amongst these 31 individuals who were looking for a forklift because they were suffering from similar aches and pains. That was concerted activity, and the employer subsequently fired them.
Counsel,
now
where
they're trying
do you
to
want to proceed?
Excuse me?
Assuming we accept the notion that the waiver of the class is no good, is illegal, where do you want to proceed in court? Do you want to proceed in arbitration? Where do you want to go forward with your class action?
Well, here, Your Honors, the respondent would prefer to go back to where it started, to the South District of New York, where it originally brought this claim. But if this court was to find that the Federal Arbitration Act actually dictated within this matter, they would have no problem vindicating their rights within the arbitral forum as a class action. And for those...
the authority to compel that?
Well, Your Honors, the Federal Arbitration Act actually just takes a liberal stance towards encouraging arbitration. Here, if this court was to find that the class action waiver was unenforceable, it could surely allow it to go forward. And it's why it's distinct from the
court compel a party to be a defendant in a class action in arbitration? Doesn't that exceed judicial authority?
Well, yes, Your Honors. According to Stolt-Nielsen versus Interstate Animal Feed, under those circumstances, whenever a contract was silent as to whether a class action could proceed, this court found that they could not compel arbitration as a class action.
Here, the contract's not silent. In fact, it says cannot proceed. So you're asking us essentially to ignore the contract and then compel class arbitration against the parties.
Exactly, Your Honors. For those reasons,
you're asking us to rewrite the contract.
Yeah, it seems.
Well, for those reasons, Your Honors, this is a more compelling situation because it's not silent. It is noted from the record that this is a violation of public policy because it's a violation of Section 7.
But that's not what you keep emphasizing. D.R. Horton, which on page 10 very clearly describes a case just like this one and distinguishing.
Well, yes, Your Honor, but here, while the facts might be different as far as whether it's a collective bargaining agreement or whether it was an agreement entered into by an employee with his employer, the fact still remains the same that the judicial forum and the arbitral forum have been shut out within these certain circumstances. I see that my time is up. Thank you, Your Honors.
Thank you, counsel. Rebuttal?
Good afternoon again, Your Honors, and may it please the Court. 2 brief points on rebuttal. First, my opposing counsel stated that the employees in this case did not request regular use of the forklifts. If I may read directly from Appendix B of the record, we, the warehouse employees of Fly Above Warehouses, respectfully request the use of forklifts on a regular basis. Secondly, with respect to the Court's concern about deference to the EEOC guidance, this Court has found on 3 occasions in Christensen versus Harris County, EEOC versus Arabian Oil Company, and National Railroad Passenger Company versus Morgan that the EEOC compliance guidelines are not entitled to Chevron deference. Thank you, Your Honors.
All rise. The judges have 10 minutes to deliberate, and then we'll come back with a decision.
I never did get the memo about
Wow, you did good. I sent my daughter out because I'm afraid she was distracted. You guys are coming in quite around here. So good. No matter what happens, I feel good. And the bench was great. Very
I gotta go to Long Island.
I'm sure you can see it on the website.
I'll look.
You know, you guys do great.
Yeah. Thank you, thank you, thank you. Thank you, Alexa, for a great tournament.
Pronounce your school. Is it University of North Carolina at Charlotte?
It's Charlotte School of Law.
Charlotte School of Law. Okay. Oh, I left my papers at home. Okay.
Congratulations, you did such a good job.
What? You guys have much fun this? Books I've read from last year. Books.
seated. So as the host of these proceedings, I'm going to defer to my fellow and sister justices to give comments. So, would you like to start?
We can start over at this end. I wanted to just compliment all of you because when you're on the bench, the one thing that really causes you to really see red is lawyers who are unprepared. You were excellent and really well prepared. You could cite to the cases, you could cite to the record. You knew, and even in the questions, you knew which cases related to which questions, so it wasn't in the abstract. So, you know, and you responded with poise. Some people, some lawyers, you know, they're tied to their notes. And while you did a glance every now and then, which you got to do sometimes, you did an excellent job of knowing where in the record and where in the law the responses that you had to make came from. And so that's the beginning of anything, because what we're looking for is that guidance to know that, you know, where it all fits in. So just as overall, I thought it was an excellent preparation. And if you keep this up, when you get out there in practice, you can come to my court and I'll be happy.
Well, let me say, this was echo that comment. I know you were well prepared, and one of the reasons I know it was because of the way you responded so readily to what I thought were some pretty tough questions. And I know you there. I happen to be the general counsel who issued the complaint in the D.R. Horton case. And I'm also obese. So I knew these areas, and I was very happy to see that you were very well prepared to answer them both. And I appreciate all the hard work that went into it and the way which you addressed us individually, but kept your eye on the bench. I noticed at one point somebody, even though I think they were talking right to me or you, the time thing came up and bang, they knew it right away. It's the ability the social ability really, when you think about it, to address an individual and a group at the same time. And you all did a good job of that.
Yeah, I would echo the comments that have been made. First of all, it was fun for us, so thank you for the chance to have done this. But also, I mean, I was just so impressed with the ability of each one of you to so quickly and with such agility respond to the rapid fire questions. And, you know, they were coming from different angles on different issues, not necessarily in any linear order. You never lost a beat. You never even seemed to pause to have to think about something that was just right at your fingertips. You know, you'd obviously thought all these things out extremely well. So you all did a great job.
Should I say they all did a bad job? Just
a balanced bench.
No, I echo, obviously, the level of preparation was extraordinary. Your familiarity with the record was mind-boggling. I sometimes have attorneys can't figure out what case they're on, and let alone what the applicable law is. You did a superlative job in not only in getting all the relevant law and the relevant cases, but integrating them in a meaningful way and responding to questions rapid fire and not being flustered by a group of egotistical judges trying to show how smart they are, which I plead guilty immediately. I'm going to make just one, I don't call it a negative comment, but an observation, particularly at the level of the Supreme Court, but at any level, even the appellate court or even a trial court. Judges like to hear not only what the law is, but why that result is a good result. And I think we had that here a little bit. We want to, why is it a good result? Why is it a bad result? Not just this case. You know, the Sixth Circuit says this, or a district court says this, which we don't care about anyhow. But why is that the right result? Why is that a good result? And I think the very best oral arguments go that way, particularly before the Supreme Court, which sort of has no constraints on it, not even precedent. Why is that the right result? Not just is it the result because the Sixth Circuit says it is. And I think maybe would have liked to hear a little more of that, but I don't want that to take away from what I consider to be a superlative argument by everybody. It was really an impressive performance.
I'll just add, at the risk of duplicating what my colleagues said, I congratulate you all and thank you for doing this. I thoroughly enjoyed it. I found that you showed a remarkable degree of enthusiasm and passion for the issue, even though you've been doing this for a while now. And even though you would say it's the finals, and so you should be excited, nonetheless, you showed the appropriate degree of passion, and I think that's a very hard thing to do, is to be passionate without going overboard. Similarly, I thought you showed a high degree of confidence without tipping to the side of arrogance. I commend all of you for your command of the facts and the law on your arguments today.
And I would just end with two observations. We've been doing this Wagner competition for a long time, and I've been at many final arguments, and I have to say this was one of the most evenly matched arguments and a very, very high quality over the years. And as you all know, it's a national competition that brings people from all over the country with expertise in these areas of law. And the second thing I would say, this was the first time that I had the pleasure of serving on the final panel, and so I don't know if this goes on frequently, but one of the reasons we took so long was because we were actually thinking about the issues and talking them over and trying to decide on the issues which way we would come out. And that says to me that it was a great problem and that it was very professionally argued because we all took them very seriously. So I thank you for that level of professionalism and seriousness.
By the way, if we had to decide the case, there'd be a plurality opinion by one justice and 5 concurrences.
Well, it's been a great couple days. I guess you can say great. And it's pretty bittersweet being up here. I really enjoyed being with all you guys and seeing now your faces for, I guess, 5 straight days. I feel like I actually live here because this is where I spend most of my time. And unfortunately, I have to be back here tomorrow morning for class in this very room. But it's been an amazing time. Thank you again for the judges. I know this wasn't easy. And again, thank you both teams. Without further ado, we'd like to congratulate Team 46, Charlotte School of Law, for winning the competition. Also, and of course, congratulations to the runner-up, Team 8, Southwestern School of Law.
And the best final round oral advocate is awarded to Christopher Campbell. Thank you, everyone, for coming today and being part of the 36th Annual Robert Wagner Competition. Have a great Sunday.
Like the Fourth Circuit judges go down and say hello to them.
Congratulations.